Hello folks, Todd Halleck here today, talking to you a little bit about the fiduciary role in your estate plan. So what is a fiduciary and what do they do? Well, a fiduciary is someone who has a heightened responsibility for someone else. Normally in the law, we owe people a duty of ordinary care to do what a reasonable person would do. But if you're serving as a fiduciary for someone, that means you need to look out for their best interest, and you need to determine if the action you're taking is not necessarily in your best interest, but in the best interest of the person that you're serving. There are several roles in an estate plan that need to be filled by individuals who would be classified as fiduciaries. But what I like to do is break those down into two silos. First, we have the financial responsibilities, looking out for the financial affairs of an individual, and then we have the healthcare responsibilities, looking out for the physical needs of an individual. The people that are serving in the financial roles don't need to be the same as the people who are serving in the physical roles. But I would strongly recommend that, generally speaking, the people serving in the financial roles are the same people, and then the people that are serving in the healthcare roles are the same people. So you could have Jane and Tom be your financial, and Sue and Dave be your healthcare, and that's fine. But I wouldn't have Jane and Tom be some of the financial jobs, and then Sue and Dave be some of the other financial jobs. Now, that's not always true across the board, but I think that's a good rule of thumb. So what are those different roles that we're dealing with? Well, if you're establishing a trust, one of the financial roles is going to be the trustee. The trustee actually owns the property that the trust holds. So if you have your home in the trustee of that trust is actually the owner of the home for all intents and purposes. And so that's a financial role. Any sort of bank account or brokerage account or real estate or business that's held in the trust, that's going to be the trustee's job to manage that. Another financial role is the personal representative or executor. You hear those terms used interchangeably depending on what state you're in. The 3 states I work in, we more commonly call that the personal representative. That's the person who gets appointed by the court to administer a probate estate. That's going to be probably someone named in your will. It could also be, if you're intestate, someone who's simply appointed by the court. But it's going to be managing assets after your death that were in your estate and had to go through the probate process. So again, for example, you have a home in your your personal name, you pass away, it's going to be the personal representative that then takes control of that property, sells it, distributes the proceeds to your beneficiaries, or distributes the property itself to your beneficiaries. That's the personal representative executor. If you have a will-based plan, that's going to be your primary financial person post-death. If you have a trust-based plan, well, we're hoping we don't have to use that person because it means something got missed and left outside of the trust. While you're alive, there's a similar court-appointed role that handles financial matters, and that's the conservator of your estate. So if you become mentally incapable of managing your own financial affairs, the court will appoint someone to manage those financial assets for you. In the states, again, that I work in, that's called the conservator of the estate. Sometimes in other states, it's called the guardian of the estate. But that person, again, is handling financial matters under the supervision of the court. That's closely aligned with the financial durable power of attorney, which would also be managing financial assets for a person while they're alive, although not under court supervision. So if we need court supervision while you're alive, conservator is going to be where we're going. If we don't need court supervision, hopefully if you have a trust, the trustee of the trust, or your agent under your financial durable power of attorney will be managing those financial assets for your benefit. The big difference between the financial durable power of attorney, the agent under that document, versus a trustee is, again, the trustee actually owns the assets, whereas the agent under the financial power of attorney is only acting as the agent of the owner. So therefore, sometimes banks or other institutions aren't going to be as likely to be willing to accept that financial power of attorney as they might in working with the trustee of a trust. Additionally, if you're putting yourself in danger, while I may, as your agent, have the power to manage your financial affairs, I can't really stop you from making mistakes, and so that's where the conservator might come in. Then there's the healthcare side. Similar to the financial power of attorney, states are going to have what is known as a healthcare power of attorney. Financial power of attorney, back to that for a second, you can have that be effective while you're competent, or it could only be effective once you become incompetent. Healthcare power of attorney, there's going to be some level of incompetency involved, meaning you're not able to express your wishes as to your healthcare needs, and so therefore this person that you've appointed will step in and make those decisions for you. That could include, and depending on the state, may include also making those end-of-life decisions. Some states have that combined in one document, others have it separated into a living will. So the living will is where you express your end-of-life wishes in terms of life support. The healthcare power of attorney is more broad, dealing with all sorts of healthcare needs that you may have, but are unable to make the choices. Similar again to the financial side, the healthcare has a court-appointed component, and that's the guardian. If the healthcare power of attorney is proving insufficient, maybe because you're a danger to yourself or possibly a danger to others, then it may be necessary to take the next step and have the court appoint the guardian. So I'm going to want to see the court-appointed guardian and the healthcare power of attorney, these same individuals filling those roles. And then on the financial side, trustee, personal representative / executor, conservator, agent under financial power of attorney, those should be, again, the same people. There's one other document that kind of has a crossover between financial and somewhat healthcare, I guess, and that's your disposition of remains on death. So obviously there's not care being given in the terms of health needs, but in disposing of your body, whether it's cremation or burial, that you have a document where you've identified who the individuals are in your group of people that you trust that would make decisions to make sure that if you want to be buried, for example, you're buried, or if you want to be cremated, you're cremated. So that's going to be the agent on your disposition of remains. Sometimes you have responsibility for others besides yourself. Maybe you have minor children, or maybe you have a disabled or an individual with disabilities that you care for, or maybe a spouse has lost mental competency. In most states, you have the right to nominate the person who will be the guardian or conservator for your minor child or for a child with disabilities as their parent. And so if you have people with that situation, you need to distinguish between whether you feel comfortable with having the same folks manage your financial affairs and your healthcare needs that would potentially be taking your minor children into their home, for example. The children that you have, or an individual with disabilities that you're responsible for, your assets may benefit them after your death, but they may also have their own assets that need to be managed, and that's where their conservator and their guardian would come in, is in managing their assets. So important to make that distinction between managing your assets and your healthcare needs and managing the assets and or healthcare needs of a minor child. So that's kind of an overview of the different fiduciary roles that when you come to see someone like me, we'll be asking you to make a decision about. Who's going to be the best to serve those roles are going to be different for every person. It could be a child, it could be a sibling, it could be a trusted advisor, it could be an independent professional that you work with. All of those can be good options for people, but what works for you is going to depend on your independent and individual situation. And so I'd really encourage you to give some thought to who will fill those roles for you as you're moving forward with your estate planning, and be prepared to make some tough decisions, but some necessary decisions. I always tell people, somebody's got to do it, right? None of us has got out of this life alive yet. And so these needs are going to arise, and it's a question of whether you get to decide who's in charge or the courts are going to decide for you. The other point I would make is it's never a good idea to put everyone in that position. I get families with 3, 4, 5, 6 or more kids, and they want to list everybody in those roles, and it's just not practical to do it that way. You're bound to have problems. I'd say 1, 2 at most are who you should be putting in those roles, and then 1 or 2 backups beyond that. So hope you found this helpful. Make sure you're getting some good advice out there on your estate planning, and most importantly, make sure you're getting it done.